it's my pleasure to introduce Kim Yanta. She is a former president of the New Jersey State Bar Association. She is a phenomenal criminal defense attorney. She's got all of the good credentials. I don't want to take up any time away from the conversation. So with that, I turn it over to Kim. You are all in excellent hands.
Good morning, everyone. It's a pleasure for me to be with you today as your speaker and moderator. We have a very good panel updating you on sexting, cyberbullying today. I know we did this panel in April, so if you were with us in April, we're happy to have you back. If this is your first time with us, then welcome. I think you will see that we have condensed a lot of information into these 2 hours. So let me get straight to introducing our panel today. First, the impetus for this program 3 years ago is Felicia Farber. Felicia is a practicing lawyer and award-winning author. When she's not writing books and winning awards, Felicia is a full-time professor and clinical director at Rutgers University School of Law. Moreover, Felicia concentrates her private practice as an arbitrator and mediator at Farber Resolutions, where she negotiates and facilitates settlements of complex disputes in multiple disciplines. She is the author, if you've been with us before, you know this, of 2 young adult novels, including Ice Queen and Fake Out. I have read them and they are excellent novels. And these books are the impetus for this presentation today. Felicia will be our first speaker today, and you'll get to have a chance to see her trailer for her book. We also have with us today Dr. Stuart Green. He's an associate director of Overlook Family Medicine Residency Program, a behavioral scientist at Overlook Medical Center in Summit, and a clinical assistant professor of family and community medicine at Sidney Kimmel Medical College at Thomas Jefferson University. Among the many projects and programs and conferences in which Dr. Green participates, of significance for this presentation is that Dr. Green founded a statewide network of groups addressing childhood bullying. He chaired New Jersey's Commission on Bullying in Schools and helped develop and obtain passage of the New Jersey Anti-Bullying Bill of Rights. So we are very pleased to have Stuart join our panel today. Next, we have Michael Kelber. He is the coordinator for online course development for Legal One, New Jersey Principals and Supervisors Association, Foundation for Education Administration. Currently working as a law consultant, Michael retired in July of 2017 from his position of Director of Legal and Labor Relations Services Department of the New Jersey School Boards Association after more than 29 years of service to the association. Loving his project work for various education organizations, it is significant to note that it is in his past life, Mike was a mathematics teacher and coach in the Woodbridge Township School District for 14 years before going to law school and becoming a practicing attorney. So Michael has that experience that many of you who are joining us today have. Welcome, Michael. And Karen Painter-Randall, formerly certified as a civil trial attorney, is a partner at Connell Foley, where she chairs the Cybersecurity and Data Privacy Group and leads the incident response team. Karen brings a wealth of technical knowledge to this panel with her extensive experience counseling clients on cybersecurity, data rights, and privacy laws and regulation. Karen provides proactive measures to safeguard the enterprise data, including security assessments, policies and procedures, security awareness training, incident response plans, and cyber liability insurance. Her clients span multiple industries, from financial services to healthcare, public entities, education, transportation, and retail, as well as lawyers and other licensed professionals. We're so very happy to have Karen with us today. And I'm Kimberly Yanta. As Kate noted earlier, I'm your facilitator for today. I launched Yanta Law in New Brunswick in 2012, where I concentrate my practice on criminal defense cases. Having represented juveniles in court and having been an assistant Hudson County prosecutor with experience in the juvenile unit, I have come to be familiar with much of the law enforcement side of the cases that involve minors in these incidents with pornography, bias harassment, and threatening behaviors. So we are ready to dig into a hot topic that keeps changing with every passing day. So let's get on with it. As you know, a lot of these updates include a lot of the different cases that have gone on in New Jersey and throughout the country, where our experts today will be talking to you a lot about that. But I want to start first with Felicia Farber. And I want to do an opening segment just to show the trailer of her book, her latest book, and what is the impetus for today's presentation.
New technology is emerging at a rapid pace, and we're now seeing more and more applications of artificial intelligence. But what happens if artificial intelligence is used against us? High school students Blair and David learned that the consequences can be catastrophic. It's hard enough to be a teenager these days, contending with bullying in school, cyberbullying online, and plus all the pressures to do well in school, to perfect the image on social media. But now there are new things to worry about, such as deepfakes. A deepfake is when someone creates an image or video that replaces a person's likeness with that of another. Their manipulated videos are very sophisticated and make the edited images sound appear to be real. In other words, with this technology, someone can take your voice and body and do whatever they want with it. Fake Out is a story about the ultimate cyberbullying with deepfakes. If you want to know what happens to David and Blair, then put Fake Out on your must-read list.
All right. Felicia, welcome. So what in your background led you to writing these books?
Well, first, thank you so much for having me here. The trailer was a great way to kick us off. I have a background in electrical and computer engineering and law, and I love creative writing. So I've combined all of these to highlight some of the major problems that our new technologies are posing on our adolescent population.
And as you know, we have a large audience from the educational community,
Yes.
and schools and principals. What would you say are the central themes of your novel, and how do they relate to these educators?
The overall central themes are about bullying and cyberbullying and many different ways that they are carried out, as well as the catastrophic effects they can have on targeted teens and tweens. In my first book, Ice Queen, I focus on sexting. I created the story where two high school students, Blair and David, are pulled into a sexting scandal, but they aren't prepared for the real life consequences that come along with being entangled in our legal system. Blair is the underdog in this story, and she's relentlessly bullied by the class mean girl, the Ice Queen, and her friends, and they use technology as weapons. Blair and David end up with criminal charges against them and face jail time, which unfortunately is all too common, and it's a realistic example of what can happen to a teenage girl in our digital age and what is happening. My cyberbullying themes continue in the sequel to Ice Queen called Fake Out, which is right behind me here. And in there, Blair and David are continuing to battle the Ice Queen, but now they have to contend with the fallout of artificial intelligence being used against them.
And what kind of AI do those characters face in Fake Out?
In Fake Out, they're dealing with manipulated media and a type of AI, as you saw in the trailer, called deepfakes. Um, and some characters are using them to try and break up the otherwise happy couple. Deepfakes are, again, altered videos and recordings of people that make it look like they're doing things or saying things that they're really not doing, to put it simplistically. What's scary is that deepfake technology has gotten so good that the false images, video, and audio it creates are hyper realistic. They appear to be authentic, and it's almost impossible to tell that they aren't. And now, virtually anybody can create a deepfake by downloading programs and software applications that are readily available to the public. So you no longer need to have a technical background or any kind of programming experience. Even more scary is that with the popularity of social media and online networking sites, there's an abundance of information out there about all of us that can be co-opted by bad actors and manipulated without our consent in really harmful ways. people put tons of data and information about themselves on Facebook, YouTube, Snapchat, Instagram, TikTok, and other platforms. And the AI can be trained on every aspect of our face and our voices to create ultra realistic false images and recordings. And once they get out there, they can spread really, really quickly through online channels. We've been seeing deep fakes used in cyber attacks in the corporate world, to fool banks and financial firms, to spread political disinformation, disrupt elections, create and spread pornography, and harass others online. So Fake Out is about how deep fakes are used against an innocent high school student, David Woods, who's a super popular, well-liked athlete, but when he is targeted with deep fakes, it upends his entire life and causes extreme damage.
And, I mean, it's just so important to stress, and I know that many people in the audience today realize how important it is, just from a standpoint of, these kids having records and how the law has not really caught up to where we're at with this technology, which hence is the reason why we're doing this today, to really talk about how the two meld today. And we've been seeing, as you kind of referenced, more and more stories about deep fakes in the news. Are there any recent stories that you can share with us right now, just to get the the discussion going, that you've seen recently?
Yes, well, of course, let me just start by saying that no one is immune from being targeted. And last year we saw that Taylor Swift was the victim of
Right,
pornographic deep fakes.
right.
The only positive thing that came out of that, because it happened to someone so famous and influential, it got the attention of our legislators and it helped to bring the issue to the forefront. But most often, these kind of incidents with deep fakes are happening to regular people. So right here in New Jersey, we had a 14-year-old girl in the 10th grade at Westfield High School who was victimized by boys. Um, these boys in her class used AI software to fabricate sexually explicit images of her and other 10th grade girls, and they circulated the pictures. And I think that incident got so well known, it was on 60 Minutes or 2020.
Yeah.
Um, and then, these types of deepfakes are happening all across America, in Beverly Hills, Hollywood, Florida, every time I turn around. And educators who used to have to grapple just with school bullying now have to deal with the challenges of students using this technology to cyberbully their classmates 24/7. I want to just talk about another incident that happened to a school principal down in Baltimore recently. He was put on administrative leave over audio recordings that sounded like he had made racist and anti-Semitic remarks. The principal said right away that the recordings were fake, not me, but people didn't believe him. And they thought, he's just making excuses. He's trying to evade accountability. And within the first few hours, these remarks got over 2 million views. And he was the object of social media hate and death threats, until it came out later that these recordings were AI generated deep fakes perpetrated by one of his colleagues. It was the school athletic director who later got arrested. But here's the major problem with deepfakes. Even when something is put out there and it's not real, the damage had taken its toll. So even after the truth came out, the deepfakes had destroyed this principal's reputation, and many people in the community still weren't sure that he didn't really say those things. Very, very scary.
It is very scary. And I know you have some PowerPoint slides you wanted to talk about. If you wanted to cue those up, we could do that right now to talk a little bit about the statistics that you and I were discussing as we were preparing for this presentation, which I think are very, very important for our audience to see today.
All right, thank you. Can you see the slides?
Yes, all good. Thanks, Felicia.
Okay, perfect. Okay, so let's get going here. I'm going to start with some bullying statistics. Research shows that bullying and harassment in schools tend to increase during late childhood and peak in early adolescence, specifically during middle school. You can see that borne out by these statistics. According to the CDC, the percentage of teenagers who were bullied in the past 12 months were higher among girls, over 38% compared to boys at about 30%. And the percentage of teens of the sexual or gender minority who were bullied were also far higher at over 47% compared to those who were not at 30%. Technology has expanded the reach of bullying and the harm it causes, which is why we are here today. Traditional bullying and cyberbullying are closely related because those who are bullied at school are bullied online, and those who bully at school bully online. According to the Pew Research Center, 59% of US teens have been bullied or harassed online and say it's a major problem for people their age. Most have experienced abusive behavior in the form of name calling, having false rumors spread about them, or they've received physical threats. 87% have observed cyberbullying, and the highest percentage of young people who cyberbullied were only 13. Interestingly, cyberbullying victims are also 9 times more likely to be the victims of identity fraud. Cyberbullying can have traumatic effects on children and young adults. 68% of kids who were cyberbullied experienced mental health issues. Girls often reported a greater impact on their friendships and well-being than boys. 2/3 of cyberbullying victims said it had a negative impact on how they felt about themselves, bringing up feelings of insecurity and self-worth. Adolescents who experienced cyberbullying were more than twice as likely to have depressive symptoms and trigger suicidal thoughts. And just so you know, teen suicide is the second leading cause of death for teens and young adults in New Jersey. Children from households with annual incomes of under $75,000 were twice as likely to be cyberbullied than those with houses with incomes above $75,000. Black teens between 13 and 7 are about twice as likely as white or Hispanic teens to say they've been cyberbullied. And LGBTQ plus students experience cyberbullying at twice the rate as their heterosexual counterparts. It's no surprise that over 93% of teens in the US and 9 out of 10 tweens use social media and gaming apps. 2 of the most popular sites are YouTube and TikTok. 70% of kids use YouTube daily, and 58% use TikTok. 46% of teens reported being the victim of online bullying on social media, and 60% have witnessed it. YouTube, Facebook, Instagram, TikTok, and Snapchat are the platforms with the most cyberbullies, and LGBTQ teens have a 5 times higher risk of being abused on Facebook. Cyberbullying is increasing rapidly. Studies show that it's grown exponentially over the past few years, which is not surprising considering the popularity of social media. This slide shows results of national surveys of middle and high school students victimized by school and online bullying in the last 30 days. As you can see, it went from 10.4% in 2007 to 26.5% in 2023, a really troubling trend. I couldn't find results for 2024 studies. I'm sure that'll be coming out soon. Sexting is sending or receiving sexually explicit material through cell phones or any type of electronic device. And this covers nude or partially nude images and videos, as well as suggestive or explicit language. The average age of the first cell ownership is 10, when 42% of kids have one. 87% of teens have an iPhone. Virtually all have access to a computer, and over half say that they've engaged in sexting. And to show you just how popular it is, over 80% of respondents between 18 and 82 have admitted to sexting in the past year. It's a big problem because, as Kim mentioned earlier, our laws are outdated. They're inconsistent or they're non-existent. And right now, teenagers that sext with each other, even consensually, can be treated under our laws as child pornographers and subject to criminal prosecution. Any sexual image of a minor is considered to be child pornography. So sexting laws vary from state to state to state and can treat minors who sext really harshly. Right now, 27 states have sexting laws. And so you're aware, most have mandatory reporting laws that require educators to report sexting to the police. Currently, there's no federal law that specifically addresses sexting and that outlaws non-consensual pornography, also known as revenge porn. But they can be a crime under federal child pornography law if it involves a minor. And we now do at least have federal statutes that allow victims to bring civil actions. As of October 2023, it's illegal to disseminate non-consensual pornography in 49 states, Guam, Puerto Rico, and DC. And the only state without a revenge porn law right now is South Carolina. All right. To give you an idea of the severity of sexting, here are some sexting behaviors that are criminal. Revenge porn, as I just mentioned, falls under invasion of privacy law in New Jersey and is a crime of the 3rd degree. A photo or a video that depicts a child engaging in a prohibited sexual act or portrays a child in a sexually suggestive manner is endangering the welfare of children and can be a 2nd or 3rd degree crime. Lewdness is New Jersey's indecent exposure statute, and this could be as simple as sending someone a picture who doesn't consent to it. Child enticement, luring or enticing a child are crimes of the 2nd degree, and this could be asking a minor for a nude photo. Child pornography, that falls under New Jersey's endangering welfare of a child statute. In New Jersey, it's illegal to possess, to view, to distribute, to share, or even receive. If someone sends it to you, it's still a crime. Any type of sexually explicit images of children under 18. There's lots of different types of media manipulation. You can manipulate language, social media, art, news, people. I'm focusing on the creation of fake images that can be used to trick people and spread disinformation. Image manipulation is the alteration of photos with the intent to deceive. Digital manipulation is modifying digital images using software tools or techniques to manipulate reality and to deceive viewers. I want to point out that media can also be manipulated for good reasons, like for creative purposes in the arts, but I'm pointing out the nefarious reasons. Synthetic media are AI-generated media that can be used as a tool by pretty much everyone from impulsive teens to scammers and criminals. Deepfakes, again, are AI-generated images, video, or audio. They first appeared in 2017, and they are now a global problem, especially when it comes to identity theft. When you look at the statistics from 2022 and 2023, you can see how fast they've infiltrated our world. In 2023 alone, over 143,000 new deepfake videos were posted, which surpasses every other year combined. I imagine 2024, when the statistics come out, will be even higher. Unfortunately, these deepfakes are often used maliciously to spread misinformation or to create non-consensual pornography. And this type of cyber harassment is growing at an unprecedented rate. Pornography now accounts for 98% of deepfake videos online, and 99% of these deepfake porn videos are of girls and women. Only 10 states have criminalized this type of non-consensual deepfake porn. Not New Jersey. We have bills proposed, but we do not have any laws yet. There's currently no federal law restricting the creation of fake sexual images of real people, but former President Biden did sign an executive order in October of 2023 urging lawmakers to bar the use of generative AI to produce child sexual abuse material or the non-consensual intimate imagery of real individuals. And the order directs our federal government to issue guidance to label and watermark AI-generated content. So that's something I'm hoping we're going to see uniformly across the country in every state, unless the AI content that is developed and produced and distributed is marked. It's almost impossible to tell if it's authentic or not. Right now, all we have are voluntary pledges from big tech, Google, Amazon, Meta, etc., saying that they agree to these safeguards to help manage all of the risks posed by Gen AI. We do have a bill proposed by Senators Ted Cruz and Amy Klobuchar. They've partnered on a bipartisan bill, the Take It Down Act, and that would require websites to have procedures in place to remove these non-consensual intimate image abuse photos and videos within 48 hours if the victim requests. Okay, so that includes the substantive portion of my slides. If you want to get in touch with me, if you have any questions, I do school visits and talks with parents too, besides educators and students. You could see my website is on top, FeliciaFarber.com. I'm running a raffle today, giving away a free signed copy of my new book, Fake Out. So if you've done this program before and you've previously entered, you can enter again. This is just for today. If you go to this website, FeliciaFarber.com, and in the contact page, if you just put in your name, I think maybe email, and NJSFA for New Jersey State Bar Foundation, NJSBF. I got it right? New Jersey State Bar Foundation. You will have entered. Another way is to go to FeliciaFarber.substack.com or use this QR code to enter. And this is, I have a newsletter. Doesn't come out very often because I wish it would, but I have multiple jobs. And I try and keep you updated on speaking engagements, how my books are doing, the latest types of sexting, cyber harassment, deepfakes, all these different things that are in the news. So it's free. So if you just hop on FeliciaFarber.substack.com, anybody that joins through tomorrow at midnight, I will enter into this raffle for my free book. Again, please feel free to reach out. I love talking about this. I'm passionate about it. And again, I do thank the New Jersey State Bar Foundation for this opportunity because it's so, so important to have everybody aware of what is going on. Without laws out there to protect us, we have to be really vigilant. And my stellar group of co-panelists coming up are going to talk to you about how this affects students and educators throughout New Jersey. So thank you again.
Thanks, Felicia. And I will say that your books are very, very well researched. From the criminal law that I could see, everything is just well researched and well done. So we appreciate you being here today. We have a couple
Thank you so much.
You're welcome. We have a couple of polls for the audience right now. If Kate wants to put those up, here we go. What social media platform is most popular with your students and children?
Kim, this is Kate. I'm just gonna jump in for 1 second. Anyone who joined us a little bit late, don't worry and don't fret. We are recording today's session. We are collecting all of the wonderful materials. They will be sent to everyone who is registered for the program, even if folks had something come up this morning and couldn't join us for that reason. We're delighted you're here. It's been so popular that our website had a momentary panic where it thought it was under attack, but it turns out it was under attack from people who wanted really wonderful information.
Thanks, Kate. So again, we have our poll questions up. And it looks like TikTok is number one. Yep, it is with my kids as well.
Not surprising at all.
I know, right? I gotta tell you, and people might not be happy with me, but I was kind of fine with a ban on it, just from a motherly perspective.
I'm with you, but
great. Okay, next poll question, Kate. We're gonna do two right now. And has anyone you know been the subject of sexting? That's a good question.
Yeah, I just want to point out that there are so many incidents that do not make it into the papers, into the news. And
So
Because
true.
I wrote these books, I am constantly contacted by people telling me these terrible things that happen to boys and girls of all ages throughout our state.
Yeah, the number of calls I get from parents, I can't even tell you, just from the criminal law perspective. All right, I think we're waiting for the results on that. Yes, 65%. And we have over 400 people in the audience today. So 65% of 428 right now. I know that there are a lot more people logging on. Thanks for coming on. We do have a large audience today. So I am going to move on to our next panelist, and it's Karen Painter Randall. Let me just reintroduce her a little bit because I know there's a lot of new people on right now. Karen is a practicing lawyer. Excuse me, she's a practicing lawyer, but she is the partner at Connell Foley, where she chairs the cybersecurity and data privacy group and leads the incident response team. Her clients span multiple industries, including education in schools and school districts, boards of administration, boards of school boards. She provides proactive measures to safeguard enterprise data, including security assessments, policies and procedures, security awareness and training. And really, she gives us our up-to-dates on what's going on, especially now with generative artificial intelligence. Karen, welcome to the panel and to today's discussion. I want to have you talk about some of the best practices, but we did already receive a question, believe it or not, and that's about how does AI distinguish versus real voice, such as the case with principals. Like, let's say principals are out there, they're giving out a message, even teachers for that matter. And then there might be some AI that takes over and takes that voice. So I know you're probably going to touch on it in your presentation. I just did not want to let that question go without letting you know that that was already been asked today.
But no, I think that's an excellent question. I think, thank you for having me. By the way, this is a very important topic, and we have some excellent, excuse me, co-panelists. Felicia, the two books, I would make it mandatory reading in the classroom, and have roundtables of discussions involving your students, and obviously they're not going to disclose their experiences, but at least sensitize them to what's going on out in the landscape. But I think, Kim, what you just referenced was something that we call voice cloning, and it really has become a very popular for what we call threat actors to use. They take someone's real voice and they clone it so that it sounds like them, but it certainly does have, you know, the person who has the fake voice doesn't have good intentions. There was actually a case involving a Fortune 500 company. The chief financial officer was getting ready to attend a meeting. It was all by way of audio. There was a discussion about wiring funds to a different bank. He could hear all of the different board members encourage the change in transfer of monies. And then he heard from the CEO, who agreed that 25 million really should be sent to this bank as opposed to the original bank who's going to receive the wire. And he was a little suspicious, but it sounded like everyone. It sounded like the CEO, sounded like the board. And so he went ahead and he wired the 25 million at a loss to the company. So that's a perfect example of voice cloning. There was no visual, it was simply audio. They obviously had no verification process in place. And they always say within the first 24, 72 hours, if you can't claw back that money, you've lost it. And in that case, they did.
Wow. Wow. I mean, you must have so many types of cases you've been dealing with regard to that. Do you have any certain types of practices that you think are the best practices for our audience here today that you can share with us?
Excuse me. I'm seeing through the people who are signing on, schools, maybe there's some school board attorneys. Everyone probably plays a different role in the best practice landscape. But it's almost like any other risk management approach. You certainly want to be aware of the issues. As Felicia said, these issues are developing over a period of time. There are new laws, there's new threats, their new exposures. AI is not helping things. AI is becoming more and more sophisticated as we talk today. AI's been around for a long time, and I'll get into that soon. But number one, stay on top of what's going on in the threat landscape. Don't think that because of what you heard today, things are done, that you know everything and you know how to handle it. It's just like incident response with breaches. If there's not someone exploring that EDR, the endpoint detection response, picking up the anomalies, picking up the patterns, if they're not evaluating that, how are they going to get better? How are they going to prevent it? So I would, maybe you want to create a subcommittee at your school just to evaluate the development of AI, Gen AI, the threats that they're producing, and how you best can protect yourself. So awareness, putting a policy in place so everyone knows what is expected of them. Evaluate that risk. Are you going to let your students use it? Are you going to let them use it in the school? You're going to let them use it outside the school? And bring in the parents with regard to that. Educate the parents, because once the students leave the school, they go home. And unfortunately, with access to so many different devices, you just don't know what they're doing on the devices or whether or not those devices are secure. So I think you have to have good collaboration with the family. So create those policies based upon risk, educate, train, have a reporting mechanism, create relationships with the law enforcement. Obviously, they get involved should any of these types of incidences that Felicia described take place. It is a team effort. Having an incident response plan, not just for breaches, but for these types of incidences that affect children. Their impact on the kids are horrible. It's embarrassing. Some of them, as Felicia showed in the stats, go on to commit suicide. You can't undo what's been done. So try to be as resilient. I don't even use the word preventive anymore. It's more resilient. Are you ready? Have you been educated? And are you ready to respond when they happen? And is it appropriate? And should we be doing more than having a principal write a letter and bringing in law enforcement? I think we need to be more proactive. I'm surprised that the laws haven't been enacted quicker, quite frankly. So if anyone on this call has any influence with your legislators, I would recommend that you step up, write a letter, and follow and put some pressure on them. There's no excuse. We should be making more progress in this space.
Yeah, so true. And I think that all of those points and action items are really important. For some of those school boards or administrators or teachers out there who this is like their first time actually having to deal with this, we're really seeing a lot with the Chat GPT and the AI assisted homework being done, for lack of a better word. Do you have any type of tidbits or interesting insight that you can share with us about any of that?
Well, keep in mind that AI has been around for a long time. It's been around since the 1950s. Everyone, you remember the IBM chess champion. We had Siri. We had Alexa. Remember Alexa and/or Siri became popular again when the election was going on. Someone had prompted it on who's going to win the election or who the better candidate is.
Right.
They freely exercise their opinion, and that was changed. And that goes to the bias that comes with the use of AI and Gen AI. Everyone remembers Sophia the robot. Beautiful. She was on every talk show host. She actually got residency or citizenship in Saudi Arabia, the first robot that ever received that. But in 2022, we really experienced rapid transformation with the Chat GPTs, the chatbots, the Gen AI, which is a subset of AI. Very, that's when you saw the kids getting on their computer, interacting, that's what, helps to create some of these attacks that Felicia described. So getting back to your question, Kim, again, understanding the technology, understanding the risks that it brings. Are you going to use it? Are you not? That's for the school to decide. But in terms of parents, what are your kids doing? I mean, there are tools out there that certainly can monitor where they are and what they're doing. But here's an example of how fast this technology is moving. 2022, you saw ChatGPT 3.0, ChatGPT 4.0, and then 2 years later, GPT 4 Omni, which they describe as a personal tutor, quite frankly. It interacts with you. And then, as you all heard in the news this week, China came up with DeepSeek. They did not need to use NVIDIA's chips to develop AI, and they developed this new model of AI within 6 months. So, and with all of this new technology, AI, Gen AI, come risks. And we can go over, a few of them today.
Yeah, please, if you would.
Sure. Let me get my my deck up here. Okay, we handled some good questions there, Kim.
Thank you
See, this
for
sets
that.
sets the tone for where we are with regard to AI, ChatGPT, how quickly it's moving. Just because it's moving quickly doesn't mean you shouldn't be staying on top of it. I'm not asking everyone, to become a technician, but it's here and it's here to stay, and it is rapidly evolving. So honestly, some of the schools on this call, it would be an excellent opportunity for you to supply updates to your parents, to your students, let them know what's going on and what potential risks might be out there. Just like we do, as you heard, I was an incident response attorney, just like we do with clients who want to make sure that they're resilient or to make sure that they can somehow prevent a data security incident. It is a holistic approach that you take. It's the same type of approach that you take with AI, Gen AI. It's used both in the school and with parents. It does have, I think Felicia mentioned, listen, new technology is great. It has some benefits and it has some risk. Here are some of the school benefits to consider. All great. But before using Gen AI in the school, has leadership sat down and decided what we want to do? I teach for a university, and before I posted the syllabus, the university actually gave me the opportunity to decide, do I want the students to use AI? And it had 2 or 3 categories on whether or not they should use it, and if they should use it, what method should they put in place to use it? Transparency, only for brainstorming, different policies if they were going to use it. Same thing with the schools. Obviously, if the kids are allowed to use it, in what setting? So these are all good, but what did you do to get to this point that you're actually using Gen AI in the classroom? Here are some ways that it is being used. Obviously, a lot of people on this call probably already know it. Teachers, I'm sure it's very helpful, helps to personalize the learning, administrators, students, and this is all general and it all has a good purpose. But the biggest question I always ask people, and I say it to everyone, when you use these tools, are you making sure that the information that you put in doesn't contain any confidential or private information? Let me just step back before I go into some of the risks that everyone on this call should be considering before deciding to use it. If deciding to use it, putting up the proper guardrails. People don't understand this technology. They don't read the service terms. They don't read the usage terms. I know no one really wants to negotiate with OpenAI. They don't want to negotiate with Microsoft, and that's fine. I understand that. But by understanding the usage and service terms, it gives you the opportunity to evaluate that risk. Let me just give you just a couple of examples of the OpenAI use and service terms. And the reason why I'm bringing this up is because if you put some of this sensitive, confidential information into your input when you prompt, the Gen AI for certain information, you could potentially expose yourself to privacy lawsuits, to actual data breaches. If you're inputting someone's name and personally identifiable information, such as name, address, social security number, medical information, school nurse information, things of that sort. Once it's in, by way of that input, you're not going to get it back. What you're doing is teaching the machine. You're expanding that machine's database, and sooner or later, if there's a name there that is connected to that sensitive information and it comes out on the other end, you could be facing serious consequences. So here are some of the terms that are in ChatGPT, the use and service terms. Number one, they want to let you know that in some situations, incorrect output may occur, and it may not accurately reflect real people, places, and facts. You should evaluate the accuracy of the output. So basically what it's saying is that it can hallucinate, it can supply you with wrong information, with incorrect information. It's only trained up to a certain year, right? So if whatever you ask it has not been trained on it, it'll actually make up an answer for you. And unless you verify whatever that answer is, again, you could be in a very uncomfortable position. I did have a client, a national managed service provider who was actually using Gen AI. They were using tools to detect who in the organization was using it and whether or not it was being used appropriately. And they called me one day and said they found through the tool that the individual had uploaded a list of 25,000 names, addresses, and some financial information of individuals who lived around the world. If that rose to the level of personally identifiable information, wherever that individual lived, because we have different laws that affect people based upon where they live, then they were going to be looking at a massive global breach. So that's how easy it can happen. I represent schools in data breaches. I know that there are Excel spreadsheets of students, of teachers, both in HR and other places, that could be placed at risk if someone was using Gen AI and decided to upload that information by using that tool. So we're getting back to training there, but it tells you that it hallucinates. And then it also tells you if you discover any vulnerabilities or breaches related to your use of the services, you must promptly contact OpenAI and provide details of the vulnerability or the breach. As a breach coach, please don't come to me and tell me that you've already reached out to OpenAI and told them that you uploaded a highly sensitive document that could rise to the level of a breach, not protected by the attorney-client privilege, and it's just going to make a mess of things. So again, maybe you accept that risk, but you train and you monitor and you have tools in place. By the way, users are going to indemnify OpenAI against any claims or losses or expenses. ChatGPT is provided to you as is. Nothing more, nothing less. You waive any class action that you would consider filing later on should something go wrong. And there is mandatory arbitration. By the way, the information that you put in is not protected by any confidentiality term, but from the open AI ChatGPT, and it is considered confidential. So you really have to understand the tech that you're using. Here are some of the other risks to using this technology. Obviously, intellectual property, malware development. Gen AI can create its own code, can through that malicious code can breach and create a ransomware attack. And you may be asking yourself whether or not that could be against you all, and the answer is yes. There was a capture the flag exercise that some scientists did with Gen AI, and when Gen AI decided that it couldn't win, it hacked itself. So these are very powerful technologies. Deepfakes, Felicia went over them. certainly the use of AI, Gen AI, to create deepfakes. It is very easy to do and does not take a lot of time. Someone in another program that I presented at actually took my voice from another program that I presented on. And for the current program, he created an audio deepfake of me. It sounded just like me. The only people that couldn't pick up on it were my family. They said, that's not you. But everyone else in the audience thought that was Karen Randall. So, and he said it took him 5 minutes
Wow.
to do. Sexting, cyberbullying, we went over making mistakes, hallucination, bias in the employment process and the insurance process based upon the algorithms. And then as you saw below, those security with the malicious code, the privacy based upon what you input when you're using those tools. And obviously, if you have a data breach, what flows from that is forensic investigation, which is costly, data mining, which could be costly, regulatory enforcement actions, FERPA violations. If there are attorneys on this call, obviously there are ethical responsibilities for you to keep your information exchanged with schools and others confidential. You take confidential information and you input it into this technology, you could waive privilege. So if you're using it at your law office, make sure that you understand how to use it. This is just
Karen, there's a question. I'm sorry to interrupt you. A couple of questions. Is there a way for individuals to determine whether or not their personal information has been contributed to an AI engine? He means without actually contributing information to it by asking. So is there a way to figure that out?
to find out if someone else inputted their information.
Yeah, someone else too. And contributed to the AI engine with your personal information.
So I think it gets back more to privacy issues. Whoever you're interacting with, making sure that they have a privacy protocol in place in terms of what am I doing with your information? You have the opportunity to delete it. You have the opportunity to see it. So I think it starts with who are you interacting with? Do they have these policies in place? And certainly with vendors, key point here with vendors, everyone on this call may say, I'm doing everything Randall is saying. We're awareness, we have the policies, we have tools to detect it. We know exactly what's going on in our environment. And then you do business with a vendor and you don't vet them. You don't find out whether or not they're using Gen AI or any type of artificial intelligence. There's no agreement with that vendor that says you are not to use any of our data and input it with any type of Gen AI that you may or may not be using. You're going through all this work and then you're going to have a vendor input that data. You are the person responsible for the data that you hold. If you share it with the vendor and they suffer a breach, it's going to come back to you unless that vendor steps up and agrees to take care of things, which sometimes they do, they don't do. I know there are a lot of schools on this call. Power School got hacked. Very simple. The threat actor used credentials that they had taken from another incident and inputted it to get into the portal, period.
So basically, you really have to just protect your personal information yourself, making sure where you're putting it and what's going on with it, because it sounds like you really don't know until an incident happens, is what you're saying.
Well, keep in mind that sometimes when people suffer an incident or a breach, they don't go through the right response efforts. So you may or may not.
So if you're saying that you can really kind of limit it by taking those measures that you need to take if there was an incident so that you're really fully protected.
Right. Understand who you're sharing your data with and what they're doing with it. Okay.
Okay.
Look at the privacy, look at the vendor agreements.
Okay, a couple more questions, Karen. Sorry, I know you had a lot of slides that you wanted to get to, but we do have some audience questions. I know you did cover a little bit about what the best ways were to safeguard our data privacy. That was one question. And then another follow-up is, I am still not understanding how someone can prove that the voice is AI. How did that principal prove it was not him so he could gain his job back?
Are you getting back to the principal?
Yeah.
Question? Okay, so in terms of how it was spotted, did someone just believe that it was the principal and no one questioned it? I mean, usually when it's used for malicious purposes, financial gain, um, you know, pulling, people into, one of these attacks that Felicia described, what happened that raised suspicion over that voice cloning? If someone could just share that with me.
I don't have any. Oh yeah, you have that, right?
Yeah, so I mean, if someone is suspicious and they suspect it, obviously, what you want to do is try to preserve that cloning, contact the right people. Obviously, it's going to be law enforcement. If you want to find out who it was, what their intentions were, we usually bring in a forensics team, who can certainly differentiate. There are methods to detect cloning, but probably easier to detect the actual visual deepfake. That gets back to understanding that there are methods to detect it, but also training people on how to detect it. Does that help?
Yeah, I think that helps. And then, one thing that I think someone was just asking also is, how do you know, because you're doing this, that someone intentionally did it? Like whether it was an accident or whether it was an intentional upload of the information.
Yeah, I don't see someone voice cloning as an accident. I see them being used to perpetrate, a scam or fraud, just like the example I gave you with 25 million. You're not going to go and clone your voice unless there's something that you hope to achieve by doing that.
What about though with, like, let's say Chat GPT and getting the information out on AI? Like what if you have like an administrative assistant in the office that just uploaded an Excel spreadsheet versus knowing that someone might have done it intentionally or purposely?
Yeah,
Is there
so
a way to figure that out?
yeah, there are accidents that happen. I've, represented people who call and say, oh my gosh, this was done by mistake, or we forwarded an email with an attachment in it that may or may not have sensitive information. So going back to the accident scenario, I think you want to encourage people. First, the training. Again, I can't emphasize that enough, but I think you need to encourage people that if mistakes are made, and they think that it involved the crown jewels or the personally identifiable information, a list of students with their social security numbers, they need to have a reporting mechanism. That's for the accidental, right?
Right.
So that you can respond to it very quickly and mitigate any exposure that you have. Sometimes you can ask the people who were on the receiving end to delete it and provide a certification of deletion. You look at who actually received it. Was it a threat actor? Probably not if it was by mistake. Was it someone's father? Was it, the risk of harm is very minimal, okay? You put yourself in a defensible position should something happen. Sometimes when accidents like that happen and social security numbers are involved, we go ahead, we get contacted and we provide complimentary credit monitoring to protect them. With regard to the intentional or malicious taking, maybe it's an insider threat. You have an employee who's not happy, and they want to take this information and either get it out there to make a headache for the school, or maybe they've made contact with an affiliate. Sometimes this information can be valuable, and they take it and they sell it. Obviously, there are tools that your IT hopefully have. Hopefully, they are scanning your systems to see if there's any unusual downloads. Usually, when something like that happens, they find out about it either through the employee or through the people who started to get unusual credit card applications, and they trace it back to, the school. Then that formal incident response method kicks in, by contacting breach coaches, forensics, finding out the who, the when, what was taken, what was exfiltrated, and what information is at risk to understand your legal and ethical obligations.
Tremendous information, Karen. We have to wrap up with you, but it was so great that you were able to answer so many questions for the audience. Do you have one final thought that you'd like to leave our audience today?
I think the most important thought for today, it gets back to understanding the technology that you really choose to use, and start from the very beginning to evaluate the risk, to make a decision on whether or not you want to use it. If the risk is low, put certain guardrails in place, understand what the risks are, make sure that you continue to train, to have a reporting mechanism in place, that you have law enforcement relationships with them, so that if something should happen, you can contain it quickly and then figure out what your next step may be. Obviously, when you run these investigations, I know with breach investigations, we do it under the attorney-client privilege. I would highly recommend that, with something like that, these attacks, that you have counsel involved to properly guide you, both for insurance reasons, but if you have communications that aren't protected and there is a claim filed later on, privacy claim, for example, you want to make sure that the investigation communications are protected by that privilege.
Excellent point. Karen, do you have a final slide with your contact information? Because I think there might be some people that want to reach out, if that's okay. I don't know if you do any school presentations or administrator presentations, but that is a question in the chat right now. So
Sure.
we're
Absolutely
putting up,
have. Yeah.
yep.
Absolutely have, and actually we presented to the New Jersey State Boards last year about this. But happy to help. There's my contact information. You can certainly Google, and the firm information is there. I think we also have the breach response, which is good for any school, any attorney, quite frankly, anyone to have that 24/7, the first 72 hours. That's the most important, and that includes all of these types of attacks as well.
All right. So feel free to take a picture of that, everybody, so you have it in your phone, and you can reach out to Karen offline. Thanks, Karen. Really appreciate it. Great information. I always enjoy your updates. I always learn so much. So thank you.
Thank you, Kim. Thanks, everyone.
So we're going to move on with our next speaker, who is Dr. Stuart Green. For those of you who weren't here when I initially introduced Dr. Green, he is an associate director of Overlook Family Medicine. One second, let me get to my intro here. And he's a person who is actually really well regarded in this field, speaks on all topics anti-bullying, because he was part of and chaired the New Jersey's Commission on Bullying in Schools and helped develop the New Jersey Anti-Bullying Bill of Rights. So welcome, Dr. Stuart Green.
All right. Thanks so much. Thanks to the bar and thanks to everybody. I appreciate the good introduction, and I appreciate Felicia's books and her good coverage of the problem. She's really the sort of core and trigger for these presentations, which are so important. I also want to note that my work is supported by Atlantic Health System and Overlook Medical Center, though my opinions are my own. I also want to note that the other co-presenters are all lawyers. So I want to say first that as an anti-bullying advocate, my admiration for lawyers who represent the families of bullied children or contribute to this cause in any way really knows no bounds. I think they're the most important profession involved in this issue. And the presenters here today are great examples of such advocates. All thanks.
Thanks, Stuart. Go ahead, you can start out where you want to start.
I'd like to go through my remarks, which should take no more than 15 minutes, and then I can deal with questions.
Good, because I already have a couple of questions queued up for you.
I just like to go through things, which will probably answer the questions, actually, and then we can take questions. So my main source of expertise in bullying comes from the phone calls I've taken from parents of children bullied at school and some educators for the past 20 plus years. Who have called the information line on my desk. I'll put this information in the chat, which anyone can call, 908-522-2581, or email to me directly at njbullying1, the number 1, @gmail.com. And all of this occurs at the doctor's office where I practice in Summit. overlook family medicine. Additional sources of expertise are the regular encounters I have with parents of children at our office for the past 30+ years. Also, my experiences in public schools as a parent of 2 boys, New Jersey public schools, and of course, the experience we all share as students ourselves in the 12 years or so we all spend as required by law in schools. And those 12 years are fraught for all of us in some way, some more than others, because those school buildings and the social environments are usually, in my experience and observation and reading, inadequately, let alone excellently run to prevent and address bullying, which is the most common form of violence in childhood. I say this while understanding how difficult the job is as a teacher or school administrator. I have a son who's a vice principal at a school. I know it's a difficult job and underpaid, actually, although New Jersey relatively better. But having said all that, we all just don't do a good enough job on this issue. And it is the most common form of violence in childhood. My response to all of that was developing after Columbine, which was April 20th, 1999, the New Jersey Coalition for Bullying Awareness and Prevention. That was that state network. And then I chaired the state's first commission on bullying in schools and co-wrote the report called There Isn't a Moment to Lose, which became the basis for the New Jersey Anti-Bullying Bill of Rights. This law passed mainly, it's important to say, with the efforts of Garden State Equality, one of the country's leading civil rights and LGBTQ organizations. And most recently, a few years ago, I folded all this work into being a founding board member of the New Jersey Alliance for Social Emotional Learning, which you can look at on the web. We'll put it in the chat at SEL. At SEL for Social Emotional Learning, the number 4NJ.org, SEL4NJ.org. So why the emphasis on schools? Willie Sutton was reportedly said that he robbed banks because that's where the money is, and most bullying occurs in schools because that's where the kids are. In your conference handouts, there should be a 5-page, single-spaced, bullet-pointed guideline for all that schools must do to address this issue proactively and with excellence, but I'll make a few key points. One is that addressing bullying is a fundamental, foundational responsibility of educators and schools. It's not an extra, an add-on. It's not secondary to education or academics. It's not something that can't be done by educators or schools unless they receive additional funding. Shouldn't need additional funding. I'm in favor of it. We recommended millions and millions of dollars a year to the state in our reports, various ones. We didn't get that money, but nonetheless, this is a core responsibility of having and running a school and being an educator. It's so fundamental that it's a failure of the education system that we actually needed a law, an anti-bullying law, to try to ensure that schools address the issue adequately. In fact, studies for the last several decades have clearly shown that in terms of academics, test scores rise like rockets. Learning and academic performance zoom upwards across the student body when a school emphasizes not teaching to the test, but instead preventing and addressing bullying and paying intense attention to the social and emotional status and functioning of all students and their peer relations. That's a key point. You want to increase your academic performance and test scores, pay attention to this. Another key point, often misunderstood still, is that bullying is not primarily a function of individual psychopathology or vulnerability, the old moose archetype from Archie comics or any of those things. It's not a function of bad families, bad kids, and bad communities. It's not. It's an institutional phenomenon, primarily caused by the way the school or other institution is run. And specifically, what we're talking about here is school culture and climate. So school culture is the norms, the rules, the expectations, the way we do things here. That's the school's culture. And out of that arises the school's climate, which is the way the place feels to the people in it, the students and everybody else, even visitors. How warm, how supportive, how inclusive, how attentive to students' needs, as opposed to how cold, how competitive, how competition-oriented. Montessori schools, for example, and Friends schools, this is not hard data, it's soft data, seem to do better in preventing and addressing bullying because of the sort of non-competitive, supportive ethos they have in those places. And in those good cultures, when the culture is good and strong in that way, educators are paying exquisite attention to the social and emotional functioning and status of all students, but especially those likely to be vulnerable or isolated. And this is not a mystery. To be clear, educators and schools are perfectly capable of understanding who their most vulnerable students are before any bullying ever occurs, before any incidents arise, and schools are capable of ensuring that those students are supported and safe, and responding if bullying does occur, some will, with the urgency and intensity that any parent of a child bullied would want. So who are those most vulnerable students? Okay, those are students with special needs, students who are gender diverse in any way, and students of heavier weight or otherwise different in appearance in any way, and those in any stigmatized or socially undersupported or minority group or status in a school. If you only have a few students in a particular group, there are some schools where there are, say 10 students who are Muslim in a school where everybody else isn't. You know in advance that those students are likely to be targeted. Not guaranteed, not in every individual case, but across that subpopulation. And this level of support and attention to these variables and those students is not yet occurring to a sufficient extent in any school of which I'm aware, law or no law. And for some children, as in New Jersey, the result is suicide. As in cases we haven't specifically referenced yet, but for example, Jack Reed in Lawrenceville, Mallory Grossman, Janet Gooch, multiple others. And the original case in New Jersey that got everyone's attention, which was the death of Tyler Clemente at Rutgers University. And in the last decade, at least since 2016 or so, there's been significant increased vulnerability of all students with significant spikes in mental health problems, suicide, substance use, everything. We see it every day in our office. And whether you attribute this change to smartphones and social media, as the social psychologist Jonathan Haidt does, you should read his most recent book, The Anxious Generation, or to the bitter partisanship of adults and the hate-filled modeling by leaders nationally and otherwise, it drives childhood vulnerability, especially of adolescents, off the charts. So when violence, psychological or physical, in other words, bullying, is layered onto all that mess, the impact is exacerbated. And again, this has not been adequately addressed. So we did need a law. But that law did a great job in raising the expectations and awareness of parents and the community. It did that, but it had significant gaps, which I and other advocates, including Garden State, we couldn't get it into the law, back when the law was enacted in 2009, put in place 2011. There were things missing from the law right from the beginning that have never been remedied to this day, despite the revisions of the law and additional task forces. I'll just mention the two most important things that have never occurred, and Mike Kalber will address this so well. He's so great, which is the law lacks support for what's called private cause of action, which any lawyer can describe. In other words, provisions and language in a civil law that specifically notes the rights and ability of parents to bring lawsuits when the tenets of the civil law have not been enacted by the institutions to which it applies. And the other thing is the law has never had any significant disciplinary or other measures for school leaders who don't adequately address this issue, which in my view, which I admit is a sort of rabid level of advocacy, I consider institutional abuse and neglect when there's high rates of bullying in a school that haven't been sufficiently addressed or remediated. But there's nothing in the law about that. And ironically, we now have in New Jersey fines for parents of bullied children, parents, but nothing for school leaders and administrators. So I'll make a couple of additional points. I think I've only used 10 minutes so far, right? Or something
Yeah, you're
like
doing
that.
great, Stuart.
Okay.
You're doing great.
So let me just do an additional thing, and I want to make re-emphasize certain points and add them. So from a systems perspective, a major cause of most cyberbullying, including sexting, deepfakes, all of it, is the sheer gross irresponsibility and management inadequacies and just egregious, horrible behavior of the social media companies, the tech companies that create and run these products. So what ends up looking like negative individual choices and behaviors is substantially invited and shaped by the behaviors the media companies encourage and allow and profit from. These media companies have profited, made huge profits from the suffering and death included of the populations, youth populations that they impact. And the other, so I'll make that point. And another point I'll make is that even though some of these bullying behaviors may require the involvement of law enforcement, certainly, physical, violence at a high level that occurs, yes, okay. But these are students in an educational setting, and it is the schools and educators primarily responsible for addressing these situations. So even if law enforcement does become involved, educators should still address the situation concurrently. And I've run into situations in schools in which law enforcement is involved and school leaders will say, we can't pay attention to the issue while law enforcement is involved. That's absolutely wrong and not required behavior. And school resource officers, which, by the way, is not an official term in law enforcement. Those are simply police officers assigned by their precinct captains to be present in the schools. They should not be the primary people addressing these issues. In fact, law enforcement, like SROs, school resource officers, have to approach conversations with students about incidents differently than educators. They would always need parents to be present when they're interviewing students, where educators don't have that sort of limitation. And by the way, in addition to all the good stuff, police do, I come from a policing family in New York, not all school resource officers are trained in addressing bullying or have the skill set to do so effectively. And notably, when the original proposed version of Mallory's law proposed making school resource officers the anti-bullying specialists in every school where they were present, the state SRO organization itself did not want to take on that role. And fortunately it was left out of the enacted version of the law. That's not to say anything negative about, Mallory's law or the incredible, amazing advocacy job of that family and Diane Grossman. Tremendous, great work. But, there were elements of it some advocates, myself, didn't agree with. Over-reliance on law enforcement, by the way, to address bullying, combined with zero tolerance policies, which totally don't work, by the way. Any educator you ever hear utter the phrase zero tolerance in regard to addressing these issues is just basically saying out loud they don't understand what bullying is or how to address it. And when you combine zero tolerance with the involvement of law enforcement, you get disciplinary disparities, which predictably most affect students of color. It's what's called the school to prison pipeline. And I'll make just one other point, two other points. Two? Yeah, okay. Then I'll stop. Cyberbullying, I think Felicia pointed this out, almost always occurs, virtually always occurs between kids who know each other from the same schools, the same communities, the same buildings. There's in-person bullying that goes on. There's cyberbullying that accompanies it. Those kids know each other. It's not strangers from across the sea, okay? Another key point. Bullying is rarely one isolated incident. what we've tried and failed to get changed in the original version of the law was that the law has this tremendous emphasis on incidents, like one incident, has occurred and now you investigate it. If you wait for an incident to occur, that's already a failure. It means you didn't sufficiently understand the vulnerability and social status of the kids that were targeted. And it's almost never one incident. In 20 years of taking phone calls from parents on this information line, I have never gotten a phone call where a parent calling the line said something bad happened to my kid yesterday, and prior to that, everything in school was perfect. No, it's typically been months or years that stuff has been happening, and this is the latest incident. And related to that point, the kids that bully, whether it's the mean girls or any other group, they have virtually never only targeted that one child where you're looking into that one incident. Those kids have been roaming around the school, being aggressive and modeling aggressive behavior toward multiple other kids or populations, and it hasn't been sufficiently addressed or prevented by the school. There's almost invariably a history to bullying incidents, what academics and clinicians call a pattern of negative acts in relationships in which there's an imbalance of power because of minority status or some other, sort of vulnerability. Although high status kids can target other high status kids in order to diminish them and thereby comparatively increase their power. So any kid can be targeted. So I think I'm about to stop. I just want to say the schools have a general responsibility to be aware of the social and emotional status of all the children in the school. All the children in the school, especially those most vulnerable. And this responsibility should be proactive, not only in response to incidents. So I'll stop there and take questions if people have them.
Yes, Stuart. We already had some questions that cover some of this. So one comment, and maybe you can give some insight. Schools are usually unwilling to cooperate with law enforcement when dealing with internal investigations, even when criminal activity is involved. What's your take on that?
Like everything in life, there's pros and cons, or as the Buddhists would say, the flowers and the garbage. So you can lean one way or the other way. Yes, so in some schools, there may not be enough cooperation with law enforcement, but that's not where the major problems are, especially for populations of color or of any minority status. The problem is, not enacting educator responsibility sufficiently so that law enforcement ends up sort of filling that gap. But yeah, I agree that that's been this questioner's experience, and sure, that does occur sometimes.
So following up on that, there's a comment and a question. When a student is physically assaulted by a bully and chooses to defend themselves, both students are often suspended, even though one was acting in self-defense.
Yeah,
This leaves many students feeling voiceless and unheard as they are punished for trying to protect themselves in what they perceive as their only option. How can we implement changes to ensure that students who are defending themselves from bullies are not unfairly punished?
Yeah, that's a perfect example of not paying sufficient attention to the social and emotional status of everyone involved and the history of the incident. This is not, parents will often complain to me that in the way the school deals with the thing, they felt like they were in an episode of Law and Order rather than an educational institution. There needs to be an understanding of who all the participants are. And if you do that, you will clearly see who is vulnerable, almost repeatedly targeted, not just one incident, and who has the history of aggressive behavior. If it really is a conflict between equals, kids of roughly equal social status with no relationship of persistent vulnerability, then it's a conflict. It's not bullying. There is such a thing as conflict between peers. That's not bullying. There is such a thing. And then it's a code of conduct violation, or you can work it out even with mediation practices, which are definitely not indicated when it's bullying. Bullying is an assault, an act of perpetration, like a mugging out in the street. You don't bring the person mugged and the person who mugged them together to work out their communication difficulties, right? Or the same thing in partner violence situations. You don't bring them together for couples counseling.
Right.
You protect and support the woman. The point is, that when that's occurred, that's a failure of perspective. It shows that what was happening was not understood deeply enough. I'm not saying that the kid bullied, has a right to fight, but the fighting, that strategy, fighting, all these recommended strategies on an individual level, urging kids to fight or take karate classes or learn to use more humor or joke it off or make friends with the kids hurting them, that stuff is wrong. It's going to work once in a blue moon anecdotally, and then it'll become like a story of how a kid fought back, like in the movies. But it virtually never works. Kids who are bullied are desperately thinking all the time, 24/7, interfering with sleep, about how to get out of that situation the next day they're at school. They've tried everything that they're capable of trying, so the fighting is not usually going to work.
So I know we only have like 1 or 2 minutes left, Stuart.
Sorry.
So I know.
Sorry.
So I want to get some of these questions. Do you have any prevention strategies to give our audience today in the schools with regard to what you just talked about? I mean, you said, they need to know. How can some of these schools do it? So for instance, you have the specialists, the anti-bullying specialists are in some of the schools, right? They should be in some of the schools, but some of them are not there because maybe the district doesn't have the money for it. They're using a counselor to do both. They're not really doing that. That's been a comment on here too. It says, so what are these strategies? Should every school have an ABS?
Well, first of all, by law, every school in New Jersey is required to have an anti-bullying specialist so designated by the principal. So
but in many cases, they're doing multiple roles, right?
Yeah, of course. And of course, it's not ideal. But the point is every school should have one, and every district should have an anti-bullying coordinator whose job is to help, etc. So the law has good structures in it, like the ABS and the safety/climate team. But I've looked at lots of those minutes of safety/climate teams, and it just doesn't operate at a high enough level of intensity. Every time an incident occurs, the safety team should take a look at that incident and scrub it to see what it reflects about a possible gap in culture and climate. If a kid who is perceived as gay or different in gender stereotype is hurt, the school should look at how strong and proactive it is in supporting LGBTQ kids. By the way, the handout that everyone should get, this 5-page bullet-pointed guide, it has everything in it, to my knowledge, that schools should be doing. So take a look at the bullet-pointed guide and see whether your school is doing all of those things.
Excellent. All right, one more question I'm going to give to you right now. So it says, how to handle cases that do not fall under distinguishing characteristics requirement, but entail imbalance of power and aggressive behavior.
Yeah, that's a widely misunderstood thing that wasn't adequately clarified in the law. The language in the law actually specifically says there doesn't have to be a distinguishing characteristic at all. Imbalance of power in that relationship can be enough. I mean, when there is a distinguishing characteristic, then the behavior may fall under New Jersey's law against discrimination, which lawyers tell me is one of the strongest in the country, if not the strongest. So that's a beautiful thing. It gives parents more power and rights, and they can turn to the Division on Civil Rights for some help and support. But it doesn't have to be one of the 7 legally, recognized or sanctioned characteristics of the LAD in order for it to be bullying. So in response to the question, imbalance of power in that relationship is sufficient. If a kid is hurt by someone else, where there is that imbalance, it's bullying. It's not conflict.
Thank you. Thank you, Stuart. This was tremendously helpful, I think, for everyone, and we really appreciate it. Thank you so much.
Sure. Yeah.
I'm going to move now to Mike Kelber for discussion on HIV and some of the updates that we've had on some of the cases in New Jersey. Mike has a PowerPoint presentation, and I think, Mike, you queued it up already. Thank you. Mike, are you there? I
I'm
think you're
there. Hold
muted.
on.
Mike. Yep. Okay.
Hold on 1 second. Just trying to get the PowerPoint going. Okay, can't start my video because the host has stopped it. Okay. Want to get us to
Take your time. You're good.
bingo. That's what I wanted to do. Okay, Kim, thank you. I'm the person between you and lunch. So that's always an interesting place to be in one of these presentations. And I'm going to apologize a little bit for my voice today. I was found to be positively tested for COVID yesterday. So I'm playing hurt a little bit today, but we're here. Fortunately, we're remote. We're able to do all this. Before I talk about my presentation, I need to touch base on a couple of things that were said previously. And I'm going to do that quickly. For all of the educators out there, right? Know your board policies on bullying, know your board policies on AI, know what your approved curriculum happen to be, and follow them accordingly. And if you don't have policies, we've heard a lot of talk about policies. I would look to Strauss Esme and maybe School Boards Association. They are the leading policy providers in the state, but know what your policy is and follow your policy. If you do that, you're putting yourself in the best place from a liability perspective. Okay. So I would strongly recommend that you do that and don't use unapproved materials. People get in trouble all the time using unapproved materials. There was a case a few years ago dealing with a staff member in my hometown in Woodbridge. And in fact, we have a few folks on the line here that was a Holocaust denier. And he sent kids to Holocaust denier websites. He ultimately was brought up on tenure charges and was fired. Why? Because he wasn't using approved curriculum. So as you start to look at all of this, make sure you're using the approved materials, make sure that you are following whatever your policies may be. And if you don't have policies, then you need to start the conversation to do that. Everybody's scrambling right now with respect to AI. So I think that's important.
Let me just say, Mike, before you start, because I didn't get a chance to kind of update everybody on your background. When Mike is telling you all of this, he is a lawyer, and he works at Legal One for NJSBF for the Foundation of Education, and he's currently an education law consultant. He did over 29 years for working for the as the director of Legal and Labor Relations Services Department of the New Jersey School Boards Association. So Mike, I mean, I just want everybody to understand when you're saying these things, it's because you do this type of work legally, and what you're saying really, really means something because it could have consequences if it's not done. So take it away. Thanks.
Okay. Did you want my video up, my picture up there?
If you want, I leave it up to you. I know you're feeling under the weather, so whatever you want to do.
I think everybody else has done that. So I think I'll do that to be consistent.
Okay.
Oh, guess not.
Just click
Right.
the video link at the bottom, no?
No, I'm clicking on here. It says I can't start it because the host has stopped it.
Oh, somebody on the tech can fix that for Mike while he starts his presentation,
Sure.
please.
Couple of things from Stuart's comment. He talked about the lack of a private cause of action. That's one of the biggest concerns from the plaintiff's bar for kids who are victims of bullying, that isn't available. The commissioner's decisions that follow up on the Anti-Bullying Bill of Rights Act, there's no damages, there's no attorney's fees. You just basically are told, you committed a violation of the act and then do whatever remediation is. So that's been a cause that people have been concerned about in terms of that. The plaintiff's bar will look at this and say, the school districts have the deep pocket and they want to go after them. They think that's going to make a difference, but that is still not the case in New Jersey under HIB law. There is a provision, Stuart talked about this. There is a provision in the code dealing with what can happen to an administrator who fails to carry out the Anti-Bullying Bill of Rights Act. We've talked about this, Stuart, maybe 2 years ago in a program in a case involving taunts and racial comments at a basketball game. I was trying to pull it up really quickly, but I didn't have that. But there is something in the code that allows that principals, supervisors who fail to do what they're supposed to do can be sanctioned. So I think that's important as well.
Yep.
The imbalance of power piece, it's not a distinguishing characteristic. I'm going to take a little issue with Stuart here when he says you don't have to have a distinguishing characteristic. What I would say is you don't have to have a protected class status. for a distinguishing characteristic. We've seen characteristics of things like they had headlights or weight or things that may not fall into protected class status that get carried through in the anti-bullying Bill of Rights
And
Act.
so just so everybody's aware, when you say protected class, you're talking about race, ethnicity, gender, religion.
And we're going to see that shortly.
Okay.
Yep. And the ABS with multiple roles, and I would venture a guess that everybody in our audience today is doing multiple roles these days. The school funding issue is really a significant issue for districts right now. I come from an education family. My wife was a teacher. Our daughter's a teacher. Our son's a teacher. Our daughter-in-law is a teacher. And we watch year by year where there's a 2% increase in property tax caps, and yet everything else goes up by more than 2%. So the ability to staff properly has become very, very difficult for folks. All right, let's see what we can do. If we can move this forward, there we go. Okay, a couple of things. You have contact information for me there, so you can get that later on if you need to contact me. This is not legal advice, even though I'm an attorney. We don't have an attorney-client relationship. This is what's all in this PowerPoint. We're going to talk about the definition, and we're going to jump to the task force and cyberbullying case law. The other material in there I think you'll find helpful. You can look at that on your own as you go through. Just a reminder, the definition. It can include gestures, written, verbal, physical acts, and electronic communication. That was not in the original law. It got into the original law in 2007, I believe, but that was added on later on. It can be a single or series of incidents, take place on school property, school-sponsored function, or school bus, or off school grounds. The gesture or act of communication has to be reasonably perceived to be motivated by any actual or perceived characteristic. Now, Kim, to your point, you see the protected class listings there, which basically would fall under the law against discrimination for most of those, or any other distinguishing characteristic. And we've seen a variety over the years as to what that distinguishing characteristic may be. Attorneys who represent students in these areas like the originals because they fall under the law against discrimination. And again, a lawsuit in that area would allow the access of attorney's fees and damages, which is not available right now under the Anti-Bullying Bill of Rights Act.
Okay.
It also has to substantially disrupt or interfere. If the kids don't care, if nothing happens, it may be bad actions. It's not HIB. We'll see that in a couple of cases. It has to also have the effect of either creating reasonable fear of physical, emotional harm to the student or damage to property, insulting or demeaning any student or group of students, or creating a hostile education environment. So one of those three. New Jersey has a very strict and specific definition of what harassment, intimidation, and bullying is. And we see cases where some of those points are not met. It doesn't mean it isn't bad action. It doesn't mean you don't discipline under code of conduct. It simply means it doesn't meet the definition under the law. Also in administrative code, you see the reference on the top of the page, it talks about the definition of harassment, intimidation, and bullying. And I've always thought this is interesting, but I don't know of anybody who has actually done this. You could actually have in your district a more expansive definition of what HIB is in your school, more so than a definition in the statute. Kind of an interesting point. You can do more. I don't know of any district that actually has done that over the years, but perhaps somebody in our audience has done that. And also in the most recent amendments from the first anti-bullying task force, you need to have a statement that bullying is unwanted aggressive behavior that may involve the real or perceived power imbalance. It's not part of the definition, but it's in your policy. You need to have that in there. We're not going to talk about these reporting requirements. I'm going to skip through these. You can take a look at those to make sure your district is doing all the things that they should be doing. We have Chapter 338, which was, at least started out as Mallory's law. It was signed into law January 10, 2022. It does provide for civil liability of parents and minors adjudicated delinquent for cyber harassment or harassment, and increases certain fines. Stuart talked about the fines, but we're going to stay past that because we got about 15 minutes. I think the cases are going to be good.
Yeah.
I do want to mention the task force report. 5 areas of recommendation came out in December. Social media was in there. The general recommendations is the department. It's a recommendation. It's not the law. Nothing has happened in the past year to implement all these recommendations. Increased role by the Department for Professional Learning Opportunities, Guidance, and Training. School districts should have climate improvement plans. Excuse me. Annual school district training, including all staff, on the role of social media and bullying. Fund the Bullying Prevention Fund. In the role of social media, you can see what was in this particular provision. The task force wants to elevate the role of the commission on the effects of social media usage on adolescents and encourages the commission to study both the role that social media plays and the impact on young people. They were supposed to have their report out within a year. I think they're probably close to that deadline, so you probably should see something from that task force shortly. Legislative developments coming down the road. A4736 was introduced in September. It hasn't moved, but things move in a gubernatorial election year slowly, and then they snowball as you get towards the election time. But this would expand the definition of HIV, specifically electronic communications, to apply to the use of deceptive audiovisual media, aka deepfakes. You see the definition listed there at the bottom. The other piece on this, which I find fascinating, and by the way, it is an NJEA supported bill. It would have teachers and staff members could be victims of HIV. Right now, teachers and staff members cannot be victims. They can be adjudicated bullies, but cannot be victims of HIV. This law would allow them to be victims as well. So a very interesting piece, and we'll see where that goes.
That was actually just a question that came up in the chat. Can HIV apply to teachers and staff? So that's in the legislation, it sounds like.
That's in this proposed legislation. What I would say is, if depending on where the bullying, harassment, intimidation is coming from, if it's a student, you've got the ability to monitor student behaviors and do things you would normally do under code of conduct. If it's from another staff member, there are ways to work within your board policies and interaction. So there's other means other than HIV. Not that anyone would weaponize it. We'll see. The last time Stuart and I did a program, well, two of the people said, our cases are really the anomalies, because for the most part, there aren't that many cases that get to this point and are actually adjudicated. I never really thought about that. So for all of the cases that get decided and where bullying is found, and there were over 9,000 bullying cases last year, these are the numbers that actually got to the commissioner where litigation actually occurred. This is from the Student Safety and Discipline Annual Report. I point out the electronic numbers here. You can see over the years how many electronic communications were there. We also have verbal, written, physical, and gesture. Last year, 20,000 investigation, 9,000 confirmed incidents, and we can do more number stuff, but we don't have time to do that today. All right, our first case. This is a case regarding impact on the people involved. If they are not uncomfortable with the discussion, it doesn't meet the definition of HIB. It could be a code of conduct piece, but not HIB. In this case, the appellate division affirmed the commissioner's determination that the board finding of no HIB was not arbitrary, capricious, or unreasonable, and that is the standard. The board determined the students were engaged in conflict. There was no evidence sufficient evidence supporting the commissioner's decision. This was an online exchange among a group of fifth grade female friends. So many of these cases turned out to be in middle school kids. Extraordinarily offensive and vile language towards each other, egregious words, sexual references, use of the N-words. The girls said, we talk this way to each other all the time. This is pranking. Nobody was really bothered by it. And so no showing of disruption, so the board found no HIB. The appellate division took the position that without any evidence that it interfered with students' ability to safely and effectively learn, no demonstrated session is substantially disrupted or interfered, no bullying. The parent of GD wanted the appellate division to take the position that anytime someone used the N-word, that should be per se an HIB violation. And the appellate division said, interesting, but that's not what the law says, and we would be effectually legislating from the court, and we're not going to do that here. Really, your remedies with the legislature. RH and MH on behalf of AH versus Board of Ed of the Borough of Sayreville. This got a lot of play last year in 2021 and a couple of years later. Here, petitioners appealed two HIB determinations. In the first one, the board determined that AH committed an act of HIB when she created a social media post depicting a friend with a mud mask on her face with the caption, "When he says he's only into black girls." A one-day suspension was imposed and AH was removed from student council. The board also determined that AH, was not the victim of HIV after incidents in which she alleged she had been called a racist and some other comments towards her, and the ALJ on appeal affirmed both decisions. Her conduct in creating the social media posts that any reasonable person should know without the effect of insulting and demeaning African American students, together with the substantial disruption it created in the operation of the school, and the fact that she was aware of the racist nature of the post, met the criteria for HIB. It was made on a platform that enabled many several middle school students to see it, thus bringing it to school where it caused a substantial disruption and interfered with the school's regular operations. You may remember the Levy versus Mahoney analysis, or at least that particular case. That's a Pennsylvania cheerleader case that made a lot of negative comments about not making the cheerleading team and not making softball, or I forget the other things. And it got into a whole Tinker versus Des Moines analysis of freedom of speech. Now, in this particular case, AH's social media posts caused substantial disruption. In Mahanoy, there was only a 5 to 10 minute discussion in algebra class. They didn't show substantial disruption. Here, a lot. The principal had to monitor lunch hour for weeks to ensure student safety and control the effects of students. They made
So
the
Mike, I'm sorry to interrupt you. That was another question in the chat, is what determines substantial disruption? It sounds like you're going through that a little bit right now.
You'll see situations here where there's substantial disruption in each of these cases. I think some of it is going to be, you know it when you see it. It has to get into the school. If you see kids that don't want to go to school, if you see a lot of discussion in the school, if you see in this particular case, there were altercations, the principal had to monitor the lunch hour for weeks to ensure student safety, that raised it up to the level of substantial disruption.
Okay.
Okay. And again, the speech here was different, where they was just expressing disagreement or criticism, although it was rather profane. Here was a racist photograph and remark that a reasonable person would perceive as offensive. The commissioner in the RH case rejected the petitioner's First Amendment argument. She said, I have a First Amendment right to say this. And they said, well, no, see, the law, the Anti-Bullying Bill of Rights Act, is something that's is within the school district's authority to regulate. Now, she claimed that she had been bullied as well, and while liked chocolate comments may have been inappropriate, no evidence to show that it substantially disrupted the school or her rights. And the commissioner concurred. Now, go a step further, 2 years down the road, and the student and her parents filed a federal lawsuit against the Cedarville Board of Ed regarding the actions that the board took. And among other things, they contended that the disciplinary actions were taken violative of her First Amendment rights. Now, she said, violated the Anti-Bullying Bill of Rights Act, and the board policy was unconstitutionally vague. It violated the First Amendment of the U.S. Constitution, the New Jersey Constitution, and New Jersey Civil Rights Act, and violated the law against discrimination. Now, in this particular case, the vagueness argument was dismissed. It said the Anti-Bullying Bill of Rights Act and the board HIB policy specific enough to give fair notice to the students and provide school officials with standards by which to enforce. And so that was dismissed. The First Amendment claim was not. Now, the interesting piece here was they did not find at the federal court level that the disturbance met the Tinker standard, Tinker versus Des Moines standard for regulation of student speech. They didn't show that there was a substantial disruption. And in the language that let this go forward, and I tried to find out what's happened in this case, and I don't know the answer. If somebody knows, please let me know. Whether her Instagram post causes substantial disruption, of course, the commissioner found that. But here they said that's ultimately an issue of fact that's inappropriate for resolution on the instant motion to dismiss. Should discovery elucidate disruption school activity, then that may place her speech outside the First Amendment. So we'll see what happens with that one. The law of discrimination claim was knocked down as well. LR on behalf of MR versus Borough Paramus, we have a parent who appealed the board finding that a student committed an act of HIV. One of the classmates received a text message with a picture of the character Stewie Griffin. I don't know Family Guy, so I don't know Stewie Griffin. You guys probably know Family Guy. But they said, hey, Stewie, what do you call someone with a big head? Actually, that was the distinguishing characteristic, the size of the forehead. It wasn't one of the protected classes we saw before, but it was the size of the forehead. Now, the student admitted to posting the video, but said it referred to it, that denied it wasn't the victim, and said it was simply an inside joke. The victim was upset, refused to return to school. There's your substantial disruption, missed several days, did not want to be in the same class as MR. The board decided this was an act of HIB. The victim's class schedule was changed, but no discipline was imposed. The ALJ, on as this was litigated, found that posting the image was done in a derogatory manner. It revealed that the student and two other girls used Stewie Griffin as a code name for the victim due to the size of her forehead, and the hurtful social media message caused the victim to miss several days of school and necessitated her transfer to other classes. The commissioner concurred with the board's decision that that was an act of HIB and was not arbitrary, capricious, or unreasonable. IR versus, on behalf of JR versus Board of Ed of the Township of East Brunswick, we have a parent who appealed two HIB determinations regarding their daughter, an 8th grade student. The board determined that the daughter committed an act of HIB when she created and disseminated a sheep meme regarding the weight and appearance of another student, and that the daughter was not the victim of HIB when the other student started a fight with her in retaliation. Now, the ALJ first reversed the finding of HIB as there were factual inaccuracies that didn't support the board's conclusion, but then also said that the daughter was not the victim of HIB because while it was a fight, there was no distinguishing characteristic. And so that was a code of conduct issue. Now, the commissioner reversed the ALJ. There was sufficient evidence to support the board's finding of HIB, which made it not arbitrary, capricious, or unreasonable. The record included testimony that the daughter showed the sheep meme to other students, that the daughter called the victim fat, a fat pig, and a fat toddler on several occasions. The commissioner affirmed the finding that the daughter was not the victim of HIB on the fight coming back. So the sheep meme was HIB, the fight in return was not.
Okay.
KW and SW on behalf of the school district of Chatham. This is one of my favorite cases of 2024 because the argument from the student was, I didn't do it, AI did it. I didn't do it, it was a chatbot. So it wasn't me, it was technology. Well, that argument didn't win, and you'll see why. So the parents appealed the board decision that their son, a 9th grader, again, just barely in high school now, right, committed an act of HIB against a fellow classmate. The parents contended the HIB determination was arbitrary, capricious, and unreasonable. And then so what did the ALJ find? Determined the HIB complaint resulted from the student posting of the N-word to a Snapchat chat group multiple times during a chatbot using a chatbot artificial intelligence app that could create words. Other members of the group posted the N-word as well, with a different ending. The chat group consisted of several 9th grade boys, one of whom was black. Although the student contends he quickly deleted the post, a few of the other boys screenshot the post, thereby preserving its content. And this electronic communication occurred on school property during school hours, disrupted the operation of the school, and triggered the investigation. What a surprise that people would screenshot the post and save it. The ALJ determined that the posting was an intentional act that could not be accidentally generated. The students should have known that posting the word to the group chat where one of the students was black would have the effect of emotionally harming that student or placing him in reasonable fear of harm to his person. And the chat post was insulting and demeaning to the black member of the group. This was done intentionally, was directed at the victim based on race, harmed the victim, and disrupted school functions. All aspects of the definition were met. So it wasn't the chatbot, it wasn't AI, it was the kid. The ALJ concluded that the parents failed to determine the board's decision was arbitrary, capricious, or unreasonable, and the commissioner concurred. HP on behalf of RS versus Board of Ed of Tenafly. We have parents, this is when trash talk goes too far. It's the old story, it's fine until it was not. So we have the parent appealing a Board of Ed decision that her freshman son committed an act of HIB against a fellow classmate. It resulted from anti-Semitic comments and threats of physical harm made by RS during an exchange on Instagram with a Jewish student in January 2023. It followed text exchanges between the two students that included back and forth insults regarding each other's perceived soccer skills. RS alleged that the Instagram messages were in response to the sarcastic comments made about his soccer game. The ABS undertook the investigation after the victim met with her guidance counselor to report the anti-Semitic comments. That's how it got to the principal, and that's how the investigation started. The threats made through a private message. The crisis team determined that RS needed a mental health clearance, which occurred. The Instagram message was nasty, anti-Semitic, and threatened the victim. The ABS found that both students made unfavorable comments regarding who was better at soccer. However, RS crossed the line in threatening to hurt the victim, as well as anti-Semitic comments about her religion. The ABS report concluded that met the definition and can constitute an act of HIB. RS received counseling and a very short suspension. The ALJ concluded that the statements were specifically targeted at the victim's religion, a distinguishing characteristic. That is a protected class, so that would be one that could also go under the law against discrimination. The messages threatened physical harm on the victim with comparisons to Adolf Hitler and the Holocaust. It wasn't just trash talk. RS escalated trash talk in exchanges into hate speech. And the ALJ found that the board's determination was not arbitrary, capricious, or unreasonable. The commissioner agreed. Now, the parent complained that the board didn't follow the process. And we see this when the board doesn't follow the process properly. The board is typically admonished and said, you need to comply with the 10-day hearing requirement as it was here, or whatever the procedural aspect may be. JR on behalf of TR versus Board of Ed of the Township of Long
So
Hill.
Mike, I'm just going to say, I'm sorry, it's 11 o'clock. I know that there are some people that may have to leave. We are going to continue so Mike can finish some of these cases. If you can stay on, great. If you can't, we understand that you would have to leave. We will go on for another 5 minutes.
Well,
so that Mike
this is
can-
the last
Good.
case.
Perfect.
Okay.
But we
JR
have
on
some
behalf of
questions for you too.
Here you go. Okay, so here's a determination by the board that HIB occurred and a 6-day suspension was imposed on another middle school student, an 8th grade student. The student was a part of a group of 7 middle school students that made numerous demeaning comments about another middle school student on an approximately 20-person Snapchat thread. The threat involved not only students in the middle school, but students from other schools as well. The comments were vulgar, attacked the victim's appearance, weight, and sexual orientation. The victim was not part of the Snapchat thread, but became aware of it later on. The comments were made known by a participant to the school counselor. One of the people on there was an upstander, went to the school counselor and said, here's what occurred. And the school counselor referred the matter to the principal. The reporting student was very concerned about retaliation to the point that the parents signed the student out of school and the student was homeschooled for the rest of the school year. That's the person who reported the information to the guidance counselor. The principal met with the 7 students, found violations of code of conduct, imposed varying levels of discipline depending on the frequency and significance of the comment. TR received the highest level of discipline, which was a 6-day out-of-school suspension. It was not the only one to get that discipline. Now, for the other side, we now have an investigation of HIB. The ABS found that the TR had committed an act of HIB in addition to the 6-day out-of-school suspension, recommended additional remedial measures, including meeting with a counselor, reflective writing assignment, and in-home risk assessment, supplemented by an additional parent meeting. TR's comments included, among others, that the targeted student looks like Medusa with her hair. Her and another student probably weigh as much as our whole friend group combined. Nobody can ever say she wakes up on the wrong side of the bed because she wakes up on both. She takes up more storage than my PC has. And why would she even take mirror pics? Like you can't even see part of her because it goes past the mirror. So pretty nasty comments coming from TR. Now the ALJ said, wasn't arbitrary, capricious, or unreasonable for the board to conclude that a reasonable person would consider these Snapchat posts to be motivated by the victim's appearance, weight, and sexuality, which would be distinguishing or perceived characteristics. There was ample evidence in the record that the Snapchat post causes substantial disruption to or interference with the orderly operation of the school or the rights of the other students. The victim was very anxious, visibly upset and crying, needed counseling sessions, was fearful of attending the high school next year. The reporting student feared retribution, had to be homeschooled. And the ABS testified there was interference in the operation of the schools, substantial interference with the school day, spoken about in the halls. Many students and staff were involved in the investigation, so a lot of stuff going on with respect to this. The comments were physically, emotionally harming, insulting, and demeaning, and created a hostile education environment. Now, TR had an interesting defense. He said, I didn't think it would ever get back to her because I was talking in a private group on Snapchat, and those chats are deleted after 24 hours. Well, that's nice, but the governing standard is objective, not subjective. A reasonable 8th grade student. Now, I'm not sure there ever is a reasonable 8th grade student. I don't know what that looks like. We had
Yeah.
2 children growing up. We have grandkids that are heading towards the 8th grade. I don't know if reasonable eighth grade student come together, but
Agreed.
we found a reasonable eighth grade student. We know the comments would be harming and that language within the group would get back to the victim. Now, the conversations were shared. Information can be screenshot or camera shot. Information among middle school students can travel, and it usually does. So the idea that you think, well, it's going to come down in one day, sorry, that didn't work for his defense. The board's finding that of him in the 6-day out of school suspension, excuse me, did not violate his First Amendment rights. There's a detailed analysis, if you're interested in First Amendment law, citing Tinker and BH versus Sayreville in terms of First Amendment rights in that area. The facts in this case were distinguishable from those in Illinois. They were the targeted another student with offensive and insulting comments about her physical appearance, and it disrupted classwork and involved substantial disorder. And the same discussion of the RH and MH versus Sayreville case there as well. All right, I've got some takeaways here, but I'm going to stop and we'll bring it up to questions, Kim.
Yeah, go ahead. You have some takeaways, you said?
Well,
Or you want to do that after? So
no,
I have a number of questions, Michael, that have been piling up. Whenever you hit on something, I kind of had you talk about it because you were there.
Okay.
So let's get going. So one is a comment and a question. I feel that the law and procedure or policy needs tiers, K through 3, 3 through 8, and 9 through 12. Having same law for students who are developmentally so different is ridiculous, in my opinion, of an anti-bullying specialist that has investigated K through 8. The question is, when you have these alleged HIB incidents, does it have to have the distinguished characteristics to be founded?
Okay, I'm going to take the last comment first. You need to have a distinguishing characteristic to meet the HIB definition under the Anti-Bullying Bill of Rights Act. You don't need to have that if you have bad conduct that you think should be changed. You have code of conduct provisions within your code of conduct policies that could lead to perhaps action being taken or whatever they may be with respect to the students. As far as the differing grade levels, I think that the reasonably prudent anti-bullying coordinator and anti-bullying specialists understand the difference at each grade level and can work accordingly in terms of fashioning findings of HIB depending on what was mentioned and also what appropriate remedies may be. There's also, we often get the question about what about a kid who gets targeted with, or not targeted, but is found to have committed an act of HIB in 3rd grade? Is that going to affect them in their college application when they're found to have been an adjudicated bully? There is a provision in the student records law code that allows for a parent to request that items be removed from a student's student record when they're no longer relevant for purposes of the education of that student. If the student has had a clean record, I think you can go through that route as well.
Okay, excellent.
Does that help?
Yeah. One of the questions is how to monitor what is sent outside of school, like screenshots of texts, body shaming, etc. How do these schools deal with that?
Well, it's hard. They deal with it when it comes to their attention. Someone has to bring it to the attention of folks in the school, and then they're able to take action on whatever that may be. And sometimes the climate is such that people are afraid to bring those actions into the school, be it with a counselor, be it with a principal, be it with somebody else, to say, hey, this is what happened, and we need to do something about it. Sometimes it's a parent that comes in and says, our son is very upset because here's what happened on the weekend. And if you can show that the student is upset, that there has now been some disruption to the school where the student doesn't want to go back to school, where kids are talking about it in school, then you have the ability to take advantage of it. I mean, to not take advantage of it, but act on it. If there's action that occurs outside of school that could arguably satisfy the school district definition of HIB, but it never comes into the school environment, it's simply something that's happened outside.
Okay. Notification question. My district notifies the parents of the determination before the board meeting and then alerts them after the board meeting that it went to the board. So we are notifying them twice. Is that permissible? The law says we only notify within 5 days after the board meeting.
Well, I'm just going to go back here real quick if I can, because I want to make sure I
Yep.
don't say anything that's not correct. Um, Actually, step 6, the parent is notified within 5 school days after of the CSA's report to the Board of Ed. So it's not after the board acts, it's actually before the board acts. And they're notified that the information of the investigation, whether HIB was found and whether discipline was imposed. Now, after the board hearing, the parents then get information in terms of what happened at the board decision. But to go back to the question, they actually do get notified twice, once before the board meeting and then once
Yep.
after, or at least they should. So the board's policy is not incorrect.
Yes, so it's supposed to be twice in answer to that question. Okay. On proposed legislation, oh, this might have been from Stuart's presentation. I don't know if I think you're still on, Stuart. An ABS specialist was concerned about what would be required to investigate matters against their own colleagues. I don't know that we're at that point yet because it is proposed legislation, but there is some concern, just so everybody is aware. I don't know if Stuart has any information about that.
No, nothing specific. I think Mike would be more of an authority than I am on that issue. I mean, I don't know, teachers being bullied and harassed. It occurs. It's not going to be common. Groups of students can certainly generate power enough to, usually with parental help, target an adult in a school, but it's not going to be the most common situation. I don't have any specific, legal knowledge.
Okay.
There
I know
is
it
a,
came up
Kim,
in,
there
go
is a
ahead.
provision in the law that talks about the not being able to investigate someone who's in the same bargaining unit.
Oh,
So,
that's right.
so you've got that in terms of the teachers as potential
Yeah,
perpetrators.
colleagues.
So
Yeah.
there's a piece in there that you can't
Okay.
investigate someone who's it. So who does the investigation then? It would need to be done by somebody else rather than someone who's in the same bargaining unit, because your ABS might very well be in the same bargaining unit with the teacher.
Yeah, that makes
Yeah,
sense.
good
Yep.
point.
Question about distinguishing characteristics. Can a distinguishing characteristic be the perception of students that someone is a quote rapist or participates in quote sexually explicit behaviors?
Absolutely. I mean, in the Jack Reed case in Lawrenceville, there were pernicious rumors, and we've had cases based on the spreading of horrible rumors, about targeted, kids, that include allegations like that, unfounded, of course. Yeah. I mean, let's see what Mike says. He's the
No,
authority.
I would agree. It's actual or perceived
Mhm.
distinguishing characteristic. So it doesn't actually have to be true. If it's perceived as such, then that could be a distinguishing characteristic. I agree.
All right,
Yeah.
excellent. It seems like there are a lot of questions about the distinguishing characteristics and the subjectiveness of what's a substantial disruption.
Okay.
Question about if a victim is in a different school. So what if you have one school and then the victim is in another school? Is there any information about that, Mike?
I think that's something that we've wrestled with from the beginning with the Anti-Bullying Bill of Rights Act. I don't know that it's ever been fully, what do I want to say, addressed in terms of just how you handle that. I think hopefully that the two schools and the two anti-bullying specialists and or coordinators can work with each other in terms of investigating that information. I know there's a piece in there, Stuart, and correct me if I'm wrong. There's a piece in there with respect to private schools for students with disabilities in terms of how they have to handle that, but I don't know there's anything generic with respect to kids in different buildings.
Yeah. No. I mean, you made the point already that, stuff that occurs anywhere is going to have an impact or could have an impact on students in a particular school. And, that's where it meets the test, does it disrupt things? Does it hurt those students?
I think what you
Yeah.
run into there is that the student who was adjudicated to have committed an act of HIB has done that on a particular school ground or school bus or school program and may not be a member of that student population. They're in another district. So the question is, when you now take the adjudication, you bring it over to the other district, how does that other district discipline that student? If they, or what do they come up with in terms of a remedial plan for that student? Because sometimes that's
Right,
because
right.
different
I mean,
government.
shouldn't we also pay attention to the fact that there is created by the law an anti-bullying coordinator, somebody in the district office, who's responsible for thinking about bullying and how it impacts the individual schools in the district and the particular ABSs? I mean, I would think a coordinator should look into that kind of thing.
Well, that's
Where,
a good point too, Stuart. Yeah. Excellent
You
point. Which
you
is,
would hope that they were doing that.
yeah, and
Mhm.
that's good for discussion.
Mhm.
Okay, a couple more questions. Similar to previously about different schools, can schools legally impose discipline such as suspension for offenders in HIV cases that occur outside of the school building? So similar to what we're just talking about.
Yeah, I mean, I don't think they can. The district that has found the HIB action, I don't know that they have jurisdiction over the student in the other district. I think what you're hoping is that the staff in District B, where the student is going to school that's been the adjudicated bully, is going to look into that particular matter. I guess you could make an argument that this is something that has occurred now off school grounds. The question is going to be for the district where the student who's been adjudicated a bully is now going to school. Do you have a connection to that school? Is there now something that's going to come into that school that's going to cause a substantial disruption? If not, and you have the adjudication in District A, District B really doesn't have jurisdiction over the discipline of that student.
Because of the lack of substantial disruption.
Yeah, it hasn't made a connection with the school.
Got you.
Yeah.
Okay. Okay, very interesting. Another question about distinguishing characteristics. What if a parent complains rather than a student? What if there is no specific victim, but the school environment has been impacted? Can a
Okay,
parent can make a complaint to the school for their child. It doesn't have to be the child themselves that does it.
right. The parent can make a complaint on behalf of their child. They can bring that to the principal and the investigation occurs. I think what I was hearing within that discussion, if the parent is concerned that the climate is not what it should be, but
Yeah.
isn't bringing forward an actual violation, alleged violation of HIB, then you're really talking about board policy and school operations, and that's probably not really something under the Anti-Bullying Bill of Rights Act. It's something that you would see perhaps discussed at a board meeting in terms of
Okay.
what that would be. I don't see where there's an ability under the Anti-Bullying Bill of Rights Act to bring an action when you don't have an act or a victim.
On the other hand, the school, when the principal becomes aware that there's an issue or a parent brings it to anyone's attention, you would hope that the school safety and climate team would take that information in and at least take a look at what the climate issue is. In other words, is the school culture and climate strong enough in supporting whatever population the parents worried about that their student is part of?
And I think the administrators who are dealing with that are going to want to know chapter and verse. They're going to know what happened. Give me examples so I can do something. I can't just act on something that's a
Right.
generic comment
Right.
that we have a problem here. You need to give me something specific.
I don't know. Do they need something specific? If a parent has a kid who has not been specifically targeted, a kid who is in a minority by religion or ethnicity, or a kid who's gender diverse or other issue, and the parent is worried about the climate of the school, is the school supportive enough? Does it have a gay-straight alliance? Has the principal helped identify mentorship and community involvement for staff members and supported that? I mean, those are all issues without a specific student having been targeted maybe yet, where a parent could raise that issue. So you're saying they should raise it with the board or the district in terms of school policy?
Well, because it's not a specific HIB, I think is what Mike is
Yeah.
saying.
Right. No,
I mean,
I hear
all
that.
of Stuart, you're right on all of those things you just said. And if something were to happen and
Mhm.
a student were injured and the parent has made all of these representations to the board and the school about what needed to be done and what the problems were. I mean, we've heard other attorneys who are plaintiffs' attorneys talk about, well, we brought it to their attention 5 times and never did anything, and look what happened.
Right.
I think that then plays itself out into the litigation.
Yeah,
But
it can. Yeah.
in terms of what it would be in terms of making school climate better, that's you work through the school climate policy if you
Yeah,
want to talk.
I just want the school safety and climate team to be robust. And one of the
Yeah,
law's big failures is the ridiculous minimal standard for safety climate team meetings, where they're only required to meet twice a year. I mean, it's just so
Mhm.
ridiculous. As to if it was a medication, it'd be almost like homeopathic or a placebo.
right.
It's just so low a
Yeah,
level.
yeah.
So yeah.
One more question. At what point do school districts get law enforcement involved? Right away? Investigate on our own to see severity and then involve law enforcement?
I think the answer to that question is my favorite legal answer. It depends.
Yep,
It depends
I
on the
agree.
matter. It depends on a uniform memorandum of agreement. It depends on what items get referred to law enforcement immediately and what
Mhm,
don't. Interesting, we've talked in the last couple of years, sexting is no longer something that's a mandatory report to law
mhm,
enforcement, which is fascinating to me. Although I would argue that maybe you could make that report as a bias incident with a protected class under gender, maybe.
mhm.
But bottom line is there are certain items within the model agreement that need to be referred to law enforcement immediately. And then law enforcement decides what they're going to do, whether they're going to push it back to the school and say, you take care of it, or whether they're going to take it on and do something with it. I think one of the biggest issues we've seen, and I don't think it's changing in the near future, we're seeing attempts to reduce the school to prison pipeline. Stuart alluded to this earlier, and looking at mechanisms where certain groups seem to be more greatly targeted for police involvement and police interference. So it's a little you have to look at the model agreement, and the answers to what gets referred to police and at what time really depends on the model agreement.
I also think, just from my background, it also depends on whether, the family and the student want to file if it rises to the level of a criminal complaint, right? Because they do have a right to file a criminal complaint if it rises to that level. And so that's certainly something that I think should be recognized, that even if the school doesn't have to report it, the parents can certainly, with their child, go to the police and file a report and go that route. And just like you're saying, there is an attempt to have a reduction in the school to prison pipeline. And I think that there has to be more done. And there is a lot being done already in our juvenile justice system to help that out. But certainly there are measures that can be implemented if it's a first offense, certainly, where you don't have to go under Megan's Law and you don't have to subject the child to that type of thing. Obviously, it's worse if there are repeated incidents against multiple victims, but certainly on the first occasion, I think there is that breadth within the law to be able to work that out. So I want to
This,
say, yep, go ahead.
oh, I'm sorry. I'm just saying we're over. I know we're past, but this is a good opportunity to just mention a side thing we didn't even mention, which is all hazing is bullying, no matter what else it is. And the new hazing law in New Jersey is even stronger than the anti-bullying law in some ways. I wish it was a sort of model. Among other things, it does have fines in it for and potential sanctions for schools that don't, usually higher ed, but that schools that don't adequately address the hazing issues. And those
Right.
are things that typically would get reported, maybe not enough to law enforcement. So anyway,
Yeah,
sorry,
it's
I didn't
true.
mean to
Very
cut you
true.
off
No, no,
there.
no.
Mhm,
We were just trying to do all the questions so that we could fit it all into the
mhm,
recording for future
sure.
distribution.
Mhm, right.
Any final thoughts?
That's it.
I would just say thank you for the opportunity to be involved in this
Yes.
today. I think it's a great program. My
Yep.
all my
Thank
fellow
you.
panelists did a great job. Kim, great job on moderating all this and keeping us on task.
Yep.
And if people have any questions, they can certainly reach out to me. I'll move this up here once again. So you have Here we go. You have contact information at njpsa.org. You can reach out to me to talk about it.
Excellent.
Absolutely. Good. And don't forget, you could put the information line, phone number, and the email address in, I don't know, somewhere. Maybe it's
We
on my
did put it, we
guideline.
put it into the
Okay.
chat earlier,
Okay, great.
Stuart.
Okay, great. Thanks very
So
much for all this. Really
thank
appreciate
you,
it.
everybody. I just
Thank
asked
you.
the speakers to stay on momentarily after we close. Thank you, everybody.